Hey guys, in this video we're going to talk about ways that you could stay in the United States despite the fact that you have a final order of removal that was issued against you by an immigration judge. Everything that's going to be discussed in this video, guys, is legal. Everything has been created by policymakers so that it could help people who are here in the United States in the unfortunate situation of facing a removal order, who have a legal pathway to lawful status in the United States. So let's get into it. The first question certainly is, can you still stay in the United States even if you have a final order of removal? And the short answer is, for some people, yes. For others, the answer is no. And we know that this issue of removing people or deporting millions of people is on the radar and on the priority list of the incoming Trump administration. So understand this issue very well if you already have a removal order, or you're in removal right now and perhaps you're worried that your case will end with a removal order. Watch this video. The very first thing that you can consider doing is appealing the decision to the Board of Immigration Appeals. Appealing the judge's decision, guys, is a timely issue. It has to happen within 30 days of that order of removal being issued. You've got to work quickly with an immigration lawyer to file an appeal with the Board of Immigration Appeals, the BIA. During the time that your appeal is pending, you have a right to stay here in the United States until that matter is resolved. Number two, file an appeal or a motion to reopen to USCIS if you have a case at USCIS that was denied. Here's what I mean by that. You're in removal or you have a removal order already issued. Perhaps you were seeking an I-130 process through a U.S. citizen spouse or another petitioner who's qualified to file for you, and that case was denied by USCIS. Well, if you have good grounds to file a motion to reopen or reconsider that decision, file that motion, because you'll need that approved I-130 to move you closer to possibly being able to reopen your removal case so that you can terminate or get rid of that removal order. So work with an immigration lawyer to find out whether you have grounds to reopen or reconsider that denied USCIS case. Your third option is to seek some sort of humanitarian relief like asylum, the U visa, or the T visa. Each of those pathways, friends, have very different and complex requirements that you must meet in order to file such a case. So for example, with asylum, you have to be able to prove that you were either persecuted back in your home country or you fear future persecution based on your race, religion, political opinion, or perhaps your membership in a social group. Work with a lawyer to determine whether an asylum case makes sense for you. And obviously, this will be a late filing, and it's even more complex to file a late asylum application, particularly if you already have a removal order. But it is not impossible. If you're eligible for it, consider asylum, or consider the U visa for crime victims. If you or a close family member have been victims of a crime, this is the pathway that could potentially help you to stay in the United States. Similarly, if you have suffered at the hands of an employer here in the United States, you might be a victim of trafficking. Reach out to a lawyer or contact us at McBean Law to see whether you might even be eligible for the T visa. It's a powerful way to help victims of labor trafficking as well as other forms of trafficking. Number four, seek cancellation of removal. Cancellation of removal, guys, is a process that will allow you to get a 10-year green card in court or through the judge. This process is very particular. It only applies to those of you who have been here in the United States for at least 10 years, you have good moral character, and you have a certain relative who will suffer extreme hardship if you have to leave the United States. Cancellation of removal is a process that can also be sought by victims of domestic violence. Speak with an immigration lawyer to see whether you have an option to reopen your immigration case so that you could seek cancellation of removal. Number five, taking your case outside of the immigration court system entirely and go into U.S. District Court or federal court with your appeal. Guys, it's possible to take your denied case or your removal order and go to a federal judge outside of the immigration system and argue your case. This is very difficult to do. do, and of course very expensive on the legal fees side of things, but it is a process that could help some people. You can take your case as far as the Court of Appeals or even to the U.S. Supreme Court. Number 6, filing a motion to reopen and terminate your removal case. Guys, this is a big one, and this is a process that we've been doing for many people over the years who have a final order of removal. This is the number one thing that I think a lot of you will be doing in 2025 and beyond. It allows you to make an argument to either the Board of Immigration Appeals, the BIA, or to an immigration judge. This process is complicated, friends. It requires you to make an argument about why your case should be reopened and terminated, including the fact that you have a pathway to a green card now, and it's a clear pathway. Either the BIA or the judge should allow you the chance of reopening your case. Now, because of how complex this is, you should absolutely work with an immigration lawyer on this process. For some people, your request will be to reopen and terminate your removal case so that you can now apply for the green card through adjustment of status at USCIS. For others, you might be asking that your removal case be reopened and remanded to be reopened so that the judge can consider cancellation of removal for you, or for some people, it might even be considering the asylum case or adjustment of status in the court or by the judge. It just really depends on the facts of your case and the procedural history. Speak with a lawyer about your case to see whether you're eligible for this process known as reopening and terminating removal proceedings. State of removal, and it is a discretionary process, bringing your request to ICE and asking that they allow you to stay in the United States temporarily so that you could pursue another pathway to a green card or your appeal. You need more time to prepare your immigration case. This is highly discretionary, and it is going to be extremely limited in 2025 and beyond. The last process is also discretionary, and it goes to ICE as well for their consideration, and it's called Deferred Action. This can happen for people who maybe have a humanitarian or medical issue happening, and they're making a request to ICE and asking that ICE would allow them to stay in the United States temporarily due to the condition that they're facing. This process is granted on a case-by-case basis only. Again, this is going to be extremely limited in 2025. Friends, I hope you found this video helpful. It is possible to stay in the United States legally after getting a final order of removal by an immigration judge, but you should work with an experienced immigration lawyer to figure out whether you qualify for any of the options that I've discussed in this video. Before you go today, guys, don't forget to subscribe to my channel and hit that notification bell so that you'll be the first to get notice of my videos each week. Thanks again for watching. Comment below, and I will see you in the next one. Bye-bye.